Emory Rogers, and I'm here with Graham Roberts from Butler Kahn Law Firm. Today I want to talk to you about a recent case that we had involving the Jones family. Graham, can you tell us a little about this case?
Yeah, we represented Thomas and Ida Jones in a car wreck case where they were struck by a young woman who was using her cell phone, rolled through a stop sign, and the ensuing T-bone collision resulted in pretty catastrophic injuries. And, unfortunately, we see this all too often with drivers using their phones. In fact, Georgia has what's called the hands-free law, meaning you're not even allowed to have your phone in your hand. And it's designed to prevent this type of accident exactly from occurring by virtue of not distracting drivers with their Instagram, their texting, and their calling while behind the wheel.
Gotcha. So this hands-free law that Georgia has, how did that play into the case?
Sure. So after the collision, the police arrived on the scene and took statements from both parties as they normally do. And in fact, this girl admitted to using her cell phone at the time of the collision. Accordingly, she was issued citations for failure to obey a traffic control device. That was for running the red light. And she was also cited for violating Georgia's Hands-Free Device Act. So she actually got 2 citations, making it very difficult for her insurance company to dispute liability in this case.
Sure. Well, it sounds like this is a pretty good wreck. Were there any issues because it was such a bad crash?
Yeah, so it was a very violent crash, and Mr. and Ms. Jones were very lucky to actually walk away from it, but not without injury. They were taken to the hospital and evaluated for injuries to their upper body as well as their lower extremities. Fortunately, no broken bones, however, pretty substantial spinal injuries, as well as a couple of tissue and ligament injuries in the form of torn meniscus and a torn shoulder.
Gotcha. So I want to talk to you about the insurance as well. So tell me about accepting and settling a case on the insurance party's terms versus on our terms and our client's terms.
Yeah, good question. In this case, our client's injuries were pretty substantial, not to mention their medical bills were astronomical. Unfortunately, the at-fault driver only had a limited amount of coverage. She had state minimum coverage of $25,000 per person, $50,000 per accident. So there was really only $50,000 in coverage to go after on her auto policy, her liability policy, that is. So what we did was we crafted a demand outlining all of the details of the collision, the liability factor, as well as our client's injuries, and presented that to her insurance company, along with very specific conditions and terms for accepting our demand in a way that our clients would be willing to accept the agreement and come to an agreement with the insurance company.
Gotcha. So how did that play out in this case then?
Well, the insurance company, unfortunately for them and their insured, did not comply with all of the terms that we spelled out. And so we were able to take advantage of that by filing a lawsuit and doing what we said we would do, which was sue their insured and expose her to a potential excess judgment. We knew that in a case like this, a jury would award well more than $50,000, the available limits of coverage, and we had told the insurance company as much. However, when they rejected our reasonable offer to settle, they put their insured's assets at risk, and so we filed a lawsuit shortly thereafter.
Gotcha. And so you filed a lawsuit. Sounds like everything's wrapped up. So what was the end result for this case?
So shortly after we filed the lawsuit, we were actually able to negotiate with our clients, the Jones Insurance Company, for their uninsured motorist coverage policy limits. They had the foresight to go ahead and purchase that additional insurance, which really isn't that much. It's not very costly, but it did afford them an additional $100,000 in coverage for Mr. and Mrs. Jones. We negotiated a settlement with them for the $100,000 per person uninsured motorist coverage limits. And right after the defendant was served, the at-fault driver, we sent a letter to her insurance company and their attorney explaining that we were about to go and get a very, very large verdict against them and point out the fact that she was using her cell phone, which we knew a jury would not be very keen on. So about 10 days later, they sent us a very large settlement check for another $200,000.
Oh, well, great job, Graham. Great job, and congrats. And glad you could get a nice recovery for the Jones family. And if y'all have any questions about this case, or you have a similar case, or questions about the Georgia hands-free law, give us a call, and we'll be happy to talk to you. Thanks.